Hello, friends. Now, I would like to welcome you to the last lecture series of unit number 6, mutual funds. This is the 10th lecture in this unit number 6. So, here we will discuss the last part of the remaining subject, that is securitization. In our previous lecture, we have already seen what the securitization is, the process of securitization, need for securitization, and uh, how securitization is required, is being done. With an example we have seen. Now in the last part of this lecture series, we will discuss the remaining part of securitization, advantages, problems in securitization, regulations governing the securitization. If you see the securitization in our country, the securitization came into existence. That is the first securitization work done in India is from Citibank in the year 1991. We have already seen that. Securitization is nothing but the converting the illiquid assets into liquid assets, where normally the financial institutions which are having the assets which are idle with them, like out the like long-term debts and medium-term debts are converted into securities, and the people involved in the security, that is participants involved in the securitization, also you have seen that the originator or the company which is having the assets, outstanding loans to receivables are converted, and the risk is transferred to the investors, like that we have already seen. Now how this securitization is advantageous to the various parties, that we will discuss in this lecture series. Now, as a part of these advantages of securitization is found to two different parties. One is to the originator, that is the company which is issuing its assets in the form of shares, what you call it, sorry, in the form of debentures and bonds, that is securitization activity. Company, what benefits it receives, and to the investors, part B, investors. So in the examination, question may be asked, what is securitization? Discuss the various advantages of securitization. You are supposed to discuss the securitization with the example, and then you should quote the advantages. The basic advantages to the originator is off balance sheet financing. What is this off balancing financing? In the sense, the finance that is being received uh, through issuing the securities reduces the assets from the what you call as mm, balance sheet, and the balance sheet becomes what you call as of the securities will get out from the balance sheet, and simultaneously the liabilities will increase on the other hand. And when the liabilities increases, the reserves and surplus of or the available in the hands of the issuing company, that is the originator company, will increase. This will give a strength to the company to give more loans and advances or expand its business further. So that is how it is most helpful. It will get the capital. Then second one is improves capital requirement automatically. When the securitization is done, the idle assets will get converted into capital. That is a more helpful to the issuing company, that is the originator companies. Then third one is it enhances the liquidity. As you know, the illiquid assets like housing loans, auto loans, long-term receivables, which are idly kept in the company, where the company is unable to do anything or expand its business, will get a chance to convert them into liquid assets, where the funds will be flowing to the business through securitization. So this will help to enhance the business. The fourth one is concentration on core business. So the companies which are having an additional assets, which are investments, which are loans and advances and all that, If they are liquidated, the core business can be concentrated and can be expanded, is another advantage. The fifth one is reduction in borrowing cost. If the company wanted to expand its business, and if it goes to stock market by issuing the IPOs for enhancing the capital, for collection of the capital, the cost of the borrowing would have been more. Whereas this securitization leads to easy way of collecting, and within less time they can collect the funds. So all that procedure involved in raising the fresh capital from the market is reduced. That is how the helpful. Another mode of financing, this is one more source of financing for the non-banking financial institutions. So that is how it is more beneficial. So these are the various advantages to the originator. What are the advantages to the investors? Investors will have an advantage to earn a high return on risk adjusted basis. They have very good investment proposals, because the securitization, when it happens, it will be issued to a corporate or investors to a limited extent. Hence the corporates will get an investment opportunity. That is how the it is benefiting to the investors, because there is a good return, as the securitized assets are also evaluated by the rating agencies, and based on the ratings, the market demand will also increase in the increase for the securitized goods, or for securitized assets. So the second important advantage is opportunity to invest in the pool of high quality credit enhanced assets. So one more is it is a pooling of assets, is that when the similar characteristic assets are drawn and the fund is created for investments, and it is converted into securities, and they are being issued in the market, will have more credit enhanced assets. So they have a quality of investments. So most of the investors will feel that they are more reliable type of investments, because the investing companies will find out it more safety than the share markets, and these prices do not fluctuate so easily as in the stock exchange markets. Then third one is portfolio diversification, alternate investment vehicles. They will get the portfolio diversification, because continuously investing in the stock markets and mutual funds is a rigidity kind of a investment proposals for most of the investors. But this kind of new type of investments will encourage them to come out with a different what you call as risk and investment combinations. So therefore, this diversification, alternate investment vehicle will definitely attract them. The last one is the bankruptcy remoteness. Investors are not affected by the insolvency of the originator, because even if the originator is getting that is insolvent, because the profit of the originating company or issuing company is not distributed as a dividend to the investors in these securitized assets. As we have already seen, the securitization asset is directly linked with the outstanding loans and advances. So automatically the obligators, or what you call as the borrowers of the company, will regularly pay the returns and satisfy the requirement of the investors. So therefore the company's performance, which is issuing the shares, that is originators performance, does not have any impact on the investors interest, because investors are not getting any money out of the dividends. They are getting the returns out of the EMIs paid by the outstanding loans and advances. So this is how most beneficial to the investors. So the next part is problems in securitization. There are a lot of problems in securitization, since the securitization is a new concept, and it is being initiated by very few originators, or the very few companies, and investors are also very limited, because it is a kind of a niche market now. Therefore, it has a certain problems of its own. One is the stamp duty is heavy in some states. So stamp duty varies from state to states for converting the securitized assets, and for what you call as agreement for investments and all that. The state governments are charging a huge amount of taxes on that. It is more costly for most of the securitization activities. This is one hurdle that we have. So the government has to pay attention in controlling this kind of a heavy duty and make a common tax procedure for all kinds of securitization processes in all the states. So that is more expected because this securitization is not directly controlled by the Securities Exchange Board of India, and there are no any other legal obligations on charging the duty and all that. That's why normally state governments will levy a heavy tax on this. This is basic problem that most of the securitization companies are facing a problem. Next one is accounting treatment. As when this kind of things are happening, there is no accounting standards, no clear guidelines in the accounting standards how to treat this. So it is treated as per the convenience of the what you call as administrators and all that, how to securitize, how to convert that particular asset and balance sheet effects and all that. There is no perfect accounting rules applicable. This is one problem. Therefore, the accounting agencies or the principles are to be applied for developing this kind of things. Third one is lack of standardization. Format of a mortgage loan agreement is not uniform. One more problem is while we are converting the assets, when we pull down the assets, all the agreements are not similar. They are different. For example, loans advances taken by the just for example from the DHFL, the customers who take the loans and advances are not having the same type of quality of assets mortgaged. They might be having a different types of mortgages, and the terms and conditions are changing from type of customer to type of customers. So this is a basic problem. So hence whenever there is a litigation on the securitized property to be settled, then the previous agreement will come into picture. The agreement between the obligators with the DHFL will come into picture when there is any problem in when securitized assets have a problem. That is, for example, if Kotak Mahindra purchases that, the risk will be need to be settled where the DHML customers will claim that the contract with the DHFL is a different something like that. So these litigations are moreover coming out in today's securitized assets, that is instruments. That is the problem. Then fourth one is foreclosure laws. No separate law for securitization. The foreclosure means in the sense that there are certain customers who have taken 20 years loans, but they may close that loan within a 5 years. When such thing happens, normally the securities which are issued against the 20 years loan contract will be having under a problem. So this is how there is no specific law for foreclosure of the assets, and separate law for securitization is not there. Then the fifth one is collateral risk, extent to which the borrowers of underlying assets will default. Collateral securities, sometimes the borrowers, when they create the default and all that, will going to affect. So the nature of borrowers, oh, that is obligators, may plays a very important role in this. So it is more risky as compared to, some people express that it is a more risky as compared to other investments, because the collateral security given for the debentures is not that quality. Suppose if the machineries are there in the company and shares are issued against the debentures are issued against the machineries, machinery value will have a depreciation as per the specific guidelines, whereas these borrowers advances, when you issue the securities against them, the attitude of the borrowers cannot be predicted. They may close it. Some people may create a default. When the default arises, it is very headache for the investors to recover that money by through a legal default. Last one is legal risk, extent to which the regulatory action can delay or prevent the payment of the investors. That is the basic problem, where the investors may not be liquidate if there are any queries to be settled in the court of law. It takes a lot of time, so delay because of legal risk. So these are the what is your problems in the securitization process. Now the last point is Regulation for securitization. As we have already seen, there is no specific regulation framework for securitization in India. There is no specific regulation because neither the SEBI will directly interfere in securitization because there is no legal procedures made available in secu- in the legal framework of the SEBI, nor any other company will any other legal things will come into picture. So this is there is no separate body in controlling the securitization process is the basic problem. The next one is the enhancement of securitization and reconstruction of financial assets and enforcement of Security Act of 2002, that is Surfacia Act, was the first uh, legislative step that enabled the securitization of the NPAs of bankers and financial institutions. See, the non-performing assets were not taken care in the earlier days, but Surfacia Act, when it came to existence, that is, Surfacia Act talks about securitization and reconstruction of financial assets and enhancement of security interest act. In case if there is any NPAs regularly happening, the issuing companies may exercise the powers to recover the assets of the non-performing mm, clients, and then those assets can be converted into securities and can be issued. So only because of Surfacia Act issued in 2002, little power has come to the what call as uh, the in the financial institutions to take charge on the debts of the company. So this is uh, one more regulating authority which helps indirectly. That is the third one is the High Level Committee on Corporate Debt and Securitization. The Patil Committee was constituted in 2005. Is an important development in the Indian financial institution. The Patil Committee has made a thorough analysis and given a guide, asked the SEBI to implement a special guideline for securitization, since securitization concept is leading to development of the Indian economy. The next one is the Reserve Bank of India guidelines for securitization of standard assets by the banks was issued in 2002 6. In 2006, SEBI has come out with a set of guidelines for securitization because in securitization there is a conversion of assets into funds, and these activities came into existence. Therefore, RBI has come out with a little guidelines on this. In 2006, Securities Contract Regulation Act was amended to include the securitization asset in the definition of the term securities. So now the Securities Contract Regulation Act, the Contract Act, is coming out. In this case, the special regulations have been created by um, Securities Contract Regulation Act in 2007. So this is giving a base for the contract clarity and all that in securitization process. Before 2007, it was very difficult to have the clarity relating to securitization. It was treated by the General Contract Act of 1881, which was not sufficient to satisfy because the nature of the securitization contract is something special and different. That is why in 2007, Securities Contract Regulation Act was amended, and securitization instruments is involved in that. This has led to, when this act came, led to listing and trading of securities papers in the stock exchanges. So now the listing of these securitized products, if it is in abundant way, they are coming for the public issues, securitized assets that came into existence. Then last one is the SEBI has released draft regulations for a public offering and listing of securitized debt instruments in June 2011, which is yet to be formalized and a regulation. Now there is a temporary arrangement was made in the year 2007 by the SEBI for regulations for debt issues, securitized debt issues, but it is not a complete controlling unit. Still, it is under the process for development and all that. So these are the various regulation bodies. In total, we can understand by this there are several attempts have been made by the country through its legal framework to regulate the securitization, but it is yet to be brought, because the securitization do not happen so regularly in all the cases. Only few companies will come out with that kind of things. That is what there is a regulatory framework missing. Proper regulatory framework is missing in securitization. This thing. Now, I thank all the students for your kind patience and involvement in the completion of the syllabus. Now, this is the last lecture where my syllabus is over. We have discussed all the 6 units one by one with the detailed discussions. I am very much thankful to all the students for patiently listening and attending these lecture series. And I hope all the best for the students. The any problems, doubts that you have, you need to clarify, you can call me or send a message on SMS or email me so that I can respond to your queries. Now the assignment submission date has already been declared. Kindly submit the assignments on that day, and we will see uh, the future days for interactions if possible. Okay, thank you one and all.